Hello there. Going through a divorce? Considering one? Sorry to hear that, but here you are. Welcome to Splitsville. You'll find Splitsville to be a pretty unique place. A new world, really, with its own rules, its own expectations, and in many ways, its own language. But don't worry, you have a knowledgeable guide along the way. And now, here she is.
Hi, I'm Lea Finegan. I'm an attorney here at Touchstone Family Law, and my practice is dedicated to settling cases outside of the courtroom. So today we're going to talk about a particular strategy known as collaborative family law. So let's dive in. I want to paint you a picture of a fictional couple named Sarah and John. Sarah and John have been married about 20 years. They have 2 teenage children. John is a banker who's been very successful. He has an intense job. He travels a lot for work. Sarah used to be a teacher, but about 15 years ago, she and John decided they wanted her to stay out of the workforce and focus on raising their family. They own a home with a mortgage, a couple of cars with some loans. They have a boat. They have a rental property that's unencumbered, and they have bank accounts, investment accounts, retirement, and some credit card debt. So John comes home one day and tells Sarah that he thinks their marriage is over. She is absolutely shocked to hear that, devastated, in fact. She begs him to go to counseling, but he maintains that his decision is made and he is ready to move forward without Sarah in his future. So what could this look like? Well, let's first look at it from a litigation perspective, and then we'll look at it from the collaborative law perspective. So John decides to move out of the house. He gets an apartment. He goes and hires an attorney, and he files a lawsuit. Files the lawsuit for equitable distribution, which is property division, and child custody. That's all he cares about at this point. So Sarah is served. She panics. Her friends give her several suggestions on big attorneys in the area that can help her. She goes and sees them. She's shocked at how expensive they are, is not sure how she's going to even access funds to pay them, but ultimately puts it on a credit card and says, let's go. They file an answer and counterclaim for equitable distribution, child custody, child support, spousal support, and they're in the litigation game. So John's attorney and him start painting a picture of Sarah that's not so pretty. They claim Sarah's lazy, that she hasn't done anything. Meanwhile, Sarah and her attorney are painting a picture of John that is also not very flattering. They claim he's a workaholic. In fact, they believe that he's had an affair. All of this is in the public realm because once you start filing lawsuits, everything is public. In Mecklenburg County and now in North Carolina, everything is in a portal that is easily accessible, even by our very savvy teenagers who know how to access things on the internet. So it's game on. Then the parties start engaging in discovery. That's issuing subpoenas, scheduling depositions, sending out formal discovery like interrogatories, requests for production of documents. They're not talking. The kids are very upset and feel torn and in the middle. They don't know what their future is going to look like. Are they going to still be able to play lacrosse and take dance lessons? Sarah's terrified because she doesn't know if she needs to go get a job, if she even can get a job. And the whole family really is in a state of chaos. Then we start court hearings. There's motions, there's interim hearings, there's mediations that are court ordered. All of this takes time. And of course, when you have attorneys involved, it takes money. So expenses can get very much out of control. So you've got emotionally exhausted people, bills that are mounting, and a lot of stress on everyone in the family. So then ultimately, you will get heard in front of a judge. I'm here to tell you that getting your case heard in court can take a very long time, particularly in some of the bigger counties in our state. I've seen cases take 2, 3, 4 years even. And at that point, you go in front of a judge who cannot possibly understand the nuances of your particular family, your needs, your concerns, your goals, and they make decisions. And what might that decision look like? Well, in Sarah and John's case, the judge orders that all of their joint property should be sold, except for the cars. They can each keep their car with the loan attached. But the house, the rental property, the boat, all of that is to be sold and split. Same with the bank accounts, the investment accounts, and the credit card debt. They're going to split it all down the middle. Secondly, they're going to give 50-50 custody. They don't really hear that John may not actually be able to do that, or he's going to have to hire help. Meanwhile, he's got to pay alimony for at least 10 years to Sarah. There's going to be child support. John, you're going to have to pay the majority of Sarah's attorney's fees because you left her in a situation where she didn't have access to funds and her attorney's fees have really mounted. So guess what? Nobody is happy. John's angry that he's had to spend all this money and he couldn't just move on. Sarah is, again, really concerned, even with her alimony that's coming in. Is it going to be enough? And the kids, where are they going to go to school now? Where are the parents going to live? I mean, it's not a good situation. So what if they went the collaborative family law approach? What would that look like? Well, we already know that John's not happy and he's ready to move forward. Even though Sarah doesn't agree, she wants him to go to counseling, she wants to try to save their marriage, John suggests that they go the collaborative route. So he hires a collaborative law attorney who makes some suggestions to Sarah as to who she might see. Sarah also goes and speaks to a collaborative law attorney. The four of them agree to have a meeting and decide how they might move forward. So at this initial meeting, they sign what's called a participation agreement. And this agreement simply states that they will not engage in any litigation. If they do, everybody leaves the table, including the attorneys. They also agree to be transparent, to produce documents as requested, and to negotiate in good faith. Then they talk about, what are your goals? What are your concerns? What are your interests? Well, Sarah lays it out there. Number one, she doesn't want to get divorced. Number two, she is scared to death to go back into the workforce, and she doesn't know how she's going to provide for the kids. She doesn't want to leave their home because the kids only have a few years before they go off to college. John, meanwhile, is ready to move forward. He has no interest in reconciling, but he doesn't want to leave the kids and Sarah high and dry. But he does have concerns. How is he going to be able to pay for two households when they only had one? So that's when they decide to get creative. Now, remember, at this point, John's still living in the home with Sarah, but he very much wants to separate. So they talk through several scenarios, and they decide that for right now, Sarah is going to stay in the marital home with the children. And fortunately, the rental property has just lost the tenant, and John's going to have an opportunity to move in there, at least on an interim basis. And the kids can stay with him when it's appropriate and when he doesn't have to travel. They're going to keep all the finances in status quo, meaning John's going to continue to put his paycheck into the joint bank account until they can figure out next steps. So they leave this meeting, hopefully feeling like they've both been heard. Sarah's not happy. She doesn't want her marriage to end. But now John has a way to move out of the house in a sane, appropriate way that hopefully is not going to make everybody really angry, including his children. And at least they can breathe and see what happens. In no way does this prevent Sarah from continuing to hope that her marriage may reconnect. It could, but it also is a way for John to feel like he can move forward. So a series of meetings are scheduled where the parties will dig deeper and they'll go into the financials. They'll go into what makes sense for the children. They'll go into, is this really the end of the marriage? And in so doing, they both feel like they can be part of the solution. They're not depending on a judge to make decisions that they may not know and have enough information about. Really, these are decisions that only John and Sarah can make in the best interest of them personally and for their children and for the long term. So what do these other meetings look like? Well, the second or third meeting, they decide they need help beyond their attorneys. They really want a financial person to come in and look at the whole picture. What makes sense from a tax perspective? What makes sense so that each of them can have an opportunity to live in a home appropriate for the kids? Sarah's still struggling and she doesn't know what to do. She has her own therapist, but she still needs additional help. So they decide we're going to use a divorce coach. We're going to bring a person in who really can help us with these emotional pieces. And John agrees to participate. He may already believe that he is solid in his determination to end the marriage, but he's willing to participate, not to be talked into staying in a marriage that he doesn't want to be in, but really to help them look forward and not backwards. So Sarah's concerns about how is she going to survive, not an easy conversation, but one that with the help of a financial neutral and a divorce coach and the attorneys, they can work through. It might not happen in one meeting. It might take several. But generally, the parties sit down, the professionals and the attorneys all brainstorm together to come up with solutions that may work. They can be very outside the box. They can be something that a court would never do or that a court would never consider. So what happens in this situation? Well, the parties ultimately decide that Sarah is going to stay in the house until the children graduate from high school. John is going to continue to live in the rental property until he can secure another home. And once he is able to do that, they're going to sell the rental property and split the proceeds. As soon as the kids graduate from college, the property is going to be put up for sale, and they will split those proceeds 50-50 as well. They're going to pay off their car loans. They're going to pay off their credit cards with joint marital funds. And that way they can each start fresh. Yes, the marriage is over, and Sarah understands that now. She's come to terms with it, and she's looking forward to her future. She's decided she doesn't want to go back to teaching. And John's agreed to help her get some additional training, some computer programming, some other key things that she needs to do to forge a new path in a career. In addition, he's agreed to continue paying for the mortgage, which is an expense of a greater degree. He's also going to continue paying for other big item purchases that are necessary for the home, to maintain it, to keep it up to date, and all of that. That's going to maintain that piece of property so that when they do go to sell it, it's going to be worth more. It's going to take some stress off of Sarah. Furthermore, they've decided to split their bank accounts, split their retirement 50-50. But when it comes to some of their investment accounts, they're going to split those on an unequal basis. And they're going to give more of it to Sarah. But in return, Sarah is going to waive her alimony or spousal support claim. And she's going to be able to invest those funds so that hopefully it will earn income and she won't feel the need to have a check or a deposit every month from John. Of course, this makes John happy because he can continue in his earning capacity and know that those funds, other than what he's going to pay to maintain the home, are his. Yes, there's going to be some child support, but that's worked out through the North Carolina child support guidelines, which is essentially a formula. So the parties leave with a very sophisticated, personalized, and beautiful arrangement that hopefully is going to keep their sanity, keep their relationship intact to the point that they need it. No, they're not going to be best friends anymore. They're not going to talk to each other every day, but they're going to maintain communication as it pertains to their children, and they're going to be respectful of each other and show their kids that yes, you can go through difficulties, but you can do it in a manner that is respectful and appropriate and maintains relationships long term. Let's have a reality check. This is not easy. Both litigation and the collaborative approach are full of emotion. Despite what John may think, even though his decision's been made, he's going to have emotional roadblocks as well. There's a lot of financial issues. Anytime you go from one family home to two, things have to be adjusted. The standard of living is not always going to be to the same degree, but it's the hope that we can keep it as equal as possible, that the children's lives won't change too much. In Sarah and John's case, they're able to keep the kids in their same school. They're able to keep them in their same extracurriculars, so that their lives, while different, are not going to be dramatically changed. The benefits of the collaborative approach are many. Generally, you save a lot of money on professional fees, even when you bring in others besides your attorneys. The time and effort involved can be much less than litigation. And the emotional factors, while still there, can be lessened. Your privacy is maintained. Everything in the collaborative approach stays there at the table between the professionals and the clients. There's no need to publicize anything or state what are in accounts and complaints and things like that. So it's really a much better avenue. So let's look forward. What are Sarah and John doing 10 years from now? Well, they've both remarried. They're happy. They both have good relationships with their children. In fact, they're celebrating their daughter's wedding. They're both on the front row. They're both sitting with their new spouses, and everybody's smiling. Their kids are relaxed. They're looking forward to having grandchildren and knowing that while they're no longer together, they both have full lives, and their children are comfortable knowing that their mom and dad put them first, and that while they might not be together anymore, they're still a family. If you want to learn more about alternatives to litigation, and in particular, collaborative family law, please contact me, Lea Finegan, at Touchstone Family Law.
So there you have it, another neighborhood of Splitsville explored. There's still so much to learn here, so I hope you'll tune in to the next episode. While Splitsville is not a fun place to be, thankfully it is full of helpful people, valuable resources, and sound advice, if you know where to look. See you next time.
The insights and views presented in Welcome to Splitsville are for general information purposes only and should not be taken as legal advice for any individual case or situation. Nor does tuning into this podcast constitute an attorney-client relationship of any kind. If you're ready for compassionate and reliable legal guidance on your journey, contact Lee Sellers and her team at www.touchstonefamilylaw.com.